that vision of the public domain, it pre-exists the 1790 Act. And I gathered that the key strategic choice was whether to go in that direction, but then face the problem that when the 1790 Congress acted, it took some things out of the public domain if it pre-existed 1790. Or whether instead to say, no, when the Congress acted in 1790, they didn't take anything out of the public domain because it didn't exist before the Congress created it in 1790. And I'm curious as to how you feel about that, because to me, the second choice, the one that was actually made, leads to the question, well, if Congress created the public domain, why can't they fool around with it? And the argument's made, well, they never have, but all right, that's true, but... And on the other hand, if you go the other way, then you have to deal with the fact that Congress kind of got the whole thing started by parceling out some public domain at the beginning. I'm just curious as to how you feel that plays now and is likely to play in the aftermath of the justices' thinking about the case, because, I mean, all plaudits to you. You did a fabulous job, Tony. You really got the justices thinking. I just salute to you.
Do you want to start or shall I?
Why don't you've been living the case.
Well, so I'm not sure it's quite the binary strategy decision you're talking about, because you have to remember that the public domain that was raided here, as I would say it, was the set of materials that Congress had placed affirmatively outside of it. In other words, Congress had done something. Everything that Section 514 takes back into protection is comprised of things Congress had brought within the federal scheme and then placed outside. So the public domain that is implicated and raided and diminished by Section 514 is the one we are talking about, that exists as a matter of the affirmative act of Congress.
It's just the rhetoric there. Congress placed it outside. Well, that imagines that Congress placed it outside rather than the outside having been there, and Congress creates a limited monopoly within it. Well, it's a very different orientation.
Sure, but what Congress did, clearly what Congress did, is it defined the scope of federal copyright regulation. You can think about it as those Venn diagrams, right? Here is the scope of everything regulated by the federal scheme. Here is something that is within that federal scheme, but they are placing it outside. When they said in 1790 that foreign authors are not going to get protection, that is placing it outside the scheme, and that is the thing that told everybody